Alright, Part 240, Qualification and Certification of Conductors, Subpart E, Dispute Resolution Procedures. 24401, Review Board established. Any person who is denied certification, denied recertification, has been his or her certification revoked, and believes the railroad is incorrectly determined that he or she failed to meet the qualification requirements of this regulation, may make a decision to deny revocation certification, may petition the Federal Railroad Administration to review the railroad decision. The Federal Railroad Administration has delegated initial responsibility for injunction in such disputes for the Locomotive Engineering Review Board. The Locomotive Engineering Review Board shall be composed of at least 3 employees of the Federal Railroad Administration selected by the administration. Alright, the petition, 24403, petition requirements. To obtain a review of the railroad decision to deny certification, deny certification, revoke certification, a person shall file a petition for a review that complies with the section. Each petition shall be written and be submitted and triplicated with the docket clerk, Office of Chief Counsel, Federal Railroad Administration, 1200 New Jersey Avenue, Southeast Washington, D.C., 20590. Containing all the available information person thinks supported with the person belief that the railroad acted improperly, including the petitioner's full name, the petitioner's current mailing address, the petitioner's daytime telephone number, the petitioner's email address, if available, the name and the address of the railroad, and the facts that petitioner believes constitute the improper action of the railroad, specifying the location, dates, and identifies that all the person who were present and involved in the railroad's action to the degree known of the petitioner. Explain the nature of the remedial action sought. Be supplemented by a copy of all the written documentations in the petitioner's possession of the document and the railroad decision. Be filed in a timely manner. Petition seeking review of the railroad decision to deny certification, recertification, filled out with the FRA more than 180 days after the date of the railroad denial decision will be denied as untimely. A petition seeking the review of the railroad decision revoking certification in accordance with the proceeding of the procedures 24307, filed with the FRA more than 120 days after the date of the railroad revocation decision, will be denied and untimely except for the Locomotive Engineering Review Board for the cause and may extend the petition filing period at any time in its discretion. 1. Provide the request of the extension of the filed expiration of the period provided with the paragraph D, or 2. Provide the failure of the timely file with the result of the excusable neglect. A party aggravated with the board of decision to deny the petition untimely mail file apply with the administrator in accordance with the 24411. Alright, processing qualification review petitions. Each petition shall be acknowledged in writing with the FRA. The acknowledgement and shall contain the document number assigned into the petition, a statement of the FRA intention for the board with the rendering decision with the petition within 180 days of the date the railroad response is received, or from the date upon which the railroad response period is lapsed and pursuant to the paragraph C of this section. Upon receipt of the petition, the FRA will notify the railroad and it has received the petition provided with the railroad with a copy of the petition. The railroad will be given the period not exceeding 60 days to submit the FRA any information that the railroad considers pertinent to the petition. Late filings will only be considered to the extent practicable. A railroad that submits information shall identify the petitioners by name and the docket number of the review proceeding. 2. The provided with a copy of the information submitted with the FRA and the petitioner submitted with the information triplicated with the docket clerk of the Federal Railroad Administration, 1200 New Jersey Avenue, Southeast Washington, D.C., 20590. Each petition will then be referred to the Locomotive Engineering Review Board for a decision. The board will determine whether the denial, revocation, certification, recertification was improper under the regulation based upon an incorrect determination that the person failed to meet the qualification requirements for this regulation, and the grant and deny the petition. Accordingly, the board will not authorize consider the proprietary railroad decision. It will not consider whether the railroad properly applied its own more stringent requirements. Notice that the decision will be provided in writing both petitioner and the railroad. The decision will include the findings of the fact in which it was based on, requesting for a hearing. If adversely affected the Locomotive Engineering Review Board decision, either petitioner before the board or the railroad involved shall have the right to administrative proceeding as prescribed in 24409. To exercise the right adversely affected with the party shall be within 20 days of the services of the board decision of the party written with the request of the U.S. Department of Transportation docket and docket operations, West Building, ground floor, room 412, 140, 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. The form of this such request may be written electronic for consistent with the standards and requirements established by the Federal Document Management System and posted on the website of the www.regulations.gov. The result of the failure to request a hearing in the period provided with the paragraph of this section is that the Locomotive Engineering Review Board decision will constitute a final agency action. If the part elects to request the hearing, the person shall submit a written request of the docket clear with containing the following: the name and address, telephone number of the respondent, the requesting party designated representative, if any, the specific factual issues, industrial rules, regulations, laws, and other requesting parties alleges the need to examine connection with the certification decision in question. The signature of the requesting party's representative, if any, upon receipt of the hearing request comply with the paragraph D of this section. The FRA shall arrange an appointment for a presiding officer who shall schedule the hearing of the earliest practicable date. 24409. Administrative hearings for the Locomotive Engineering Qualification petition shall be conducted by presiding officer who can be any person authorized by the administrative, including any administrative law judge. The presiding officer may exercise the power of administration to regulate the conduct of the hearing for the purpose of achieving the prompt and fair determination of all the parties' material issue with the controversially. C. The presiding officer shall convey with the presiding over the hearing. The hearing shall be de novo hearing to find the relevant facts and determine the correct application of the part of those facts. Presiding officer may determine that there is no genuine issue covering some of all the material facts and limits of evidentiary proceedings issue and material facts as those which is the genuine dispute. The presiding officer may authorize discovery of the type of the quantities which was presided in the presiding officer's discretion to contribute to a fair hearing without unduly burden in parties. The presiding officer may impose appropriate non-monetary sanctions, including limitations to the presentation evidence and issue for any party without failure of the refusal to comply with the approved discovery request. Every petition, motion, response, and authorized required document shall be signed and partly filing the same, the duly authorized officer and representative of the record, and by any of the other person, if signed such as any of the person. The reason, therefore, of must be stated before power of the attorney and other authority authorizing such other person to subscribe. The document must be filled in with the document. The signature to the person subscribing any document constitutes a certification that he or she read the document, that to the best of his or her knowledge and the information belief of every statement contained with the document is true, no such statements are misleading, and that is no interposed with it for delay or to vexatious. After the request for the hearing is filled with all the documents filled with served upon one party must be served upon all the parties. Each party may designate a person upon whose service is to be made, whether specified by the law. When not specified by the law, regulate the directive of the presiding of the officer. If the party does not designate a person upon whom the service is to be made, the service may be made upon any person having subscribed to a submission of the party being served, unless otherwise specified by law, regulation, directive, presiding officer. Proof of the service shall accompany all documents when tendered for filing. G. If a document initiating file with the servicing proceeding with is not substantial compliance with the application law, regulation, directive to the presiding officer may strike or dismiss all or part of the such document requiring its amendment. Any part or proceeding may appear heard in person or by an authorized representative. Any person testifying to hear the deposition may be accompanied by the representative advised by attorney or other representative may be examined by that person. Any party requesting consolidation separate with the hearing of two more petitions by motion to which the presiding officer, when they arise from the same and similar facts, when the matter are for any reason deemed more effective, efficiently heard together. Okay, except as provided in Part 240-407C, the paragraph in U4 of this section, whether the party has the right is required to take an action with the period prescribed in this part by a law, regulation, directed by the presiding officer may extend such a period with or without notice for a good cause provided with another part of the non-substantial prejudice by such extension. Request extended for the period for the already expired by the denied untimely. Um, L. An application presiding with the officer ordered with the ruling not otherwise specifically provided in this part shall be motion with the motion shall be filled with the presiding officer. If written, served upon all the parties, all motion, unless during the hearing shall be written. Motions during the hearing may be made orally or on the record, except that they are presiding officer may direct that oral motion to reduce to writing. Any of the motion shall state the particular grounds, therefore, of the relief of the oversought, and there shall be accompanied by affidavits and other evidence desired to be relied upon on which is not already part of the record. Any matter submitted the response of the written of the motion must be filled within served and within 14 days of the motion within other periods as directed by the presiding officer. Alright, and testimony by witness at the hearing shall be given under the oath, and hearing shall be recorded verbatim. The presiding officer shall give the parties to the proceeding adequate opportunity during the course of the hearing for presentation, augmentation, arguments, and supporting the opposition to the motion, objects for the exemption for the rulemaking presiding officer. The presiding officer may permit oral arguments of any issue to which the presiding officer deems appropriate with the beneficial and evidence argument received with the preferred orally shall be transcribed, and any made part of the record, the physical evidence of the written argument received with the preferred offered shall be made part of the record of the except for the presiding officer may authorize the substantial of the substitution of copies and photographs and descriptions were deemed appropriate. And the presiding officer shall employ the federal rules of evidence for the United States courts and magistrates as general rules introduced into the evidence, notwithstanding the paragraph of this section. All relevant probative evidence shall be received unless the presiding officer determines the evidence of unduly repetitive, so extensive, lacking in relevance of the admission when they impair of the prompt, orderly, and fair resolution of proceeding. The presiding officer, 1, administrates the oath and affirmations. 2, issues the subpoenas provided in Part 209.7 of Part 209 of this chapter. Adopt any need for procedure for the submission of evidence of the written form, examine the written witness from the hearing, conveying the recess of the adjourning other than wise regulated with the course of the hearing, and take any action authorized with the consistent with the provisions of the part permitted with the law of the bank expedited hearing and aid for the disposition proceeding. The petitioner before the Locomotive Engineering Review Board, the railroad involved with taking the certification action, and the FRA shall be part of the parties at the hearing. The parties of the particular participate in the hearing, and it may appear with the heard on behalf of through the designated representative of all the parties other than offer relevant evidence, and including his testimony, may conduct with such cross-examination of the witness as may be required to make record of the relevant facts. The party requisition administration hearing shall be hearing a petitioner. The hearing petitioner shall have the burden proving its case and preponderance for the evidence, and hence the hearing petitioner in the railroad involving taking certification action. The railroad will have the burdens proven as the decision denying certification, denying recertification, revoking certification was correct. Conversely, the petitioner made before the Locomotive Engineering Review Board is a hearing petitioner, but the person with having the burden proving the railroad decision denying certification, denying recertification, revoking certification was incorrect between the petitioner before the Locomotive Engineering Review Board of the railroad involved with the taking the certification action. The party who in his is not the hearing petitioner will be respondent. The FRA will make a mandatory party with the administrative hearing at the start of each proceeding. The FRA will be the respondent. As the record of proceedings shall be closed conclusion with the evidentiary hearing unless the presiding officer allows additional time for the submission of additional evidence. In such instances, the record shall be left open for such time as presiding officers grant for the purpose. At the close of the record, the presiding officer shall prepare a written decision in the proceeding. The decision shall contain a finding of the fact, the conclusion of the law, well as basis of the shall each concerning with the material issue of the fact of the law presented on the record shall be served on the hearing of the petitioner all the other parties for the proceeding. 3 shall not become final within 35 days after the issuance. Constitute final agency action unless aggravated with the party files an appeal within 35 days after the issuance and is not precedently. Alright, 244.11 appeals. Any party aggravated with the presiding officer's decision may file an appeal. The appeal must be filled without in 35 days issuing the decision within the Federal Railroad Administrator. 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. A copy of the appeal shall be served for each of the party. The appeal shall set forth the objections to the presiding officer's decision, supported with the reference, applicable law, regulations, specific reference if the record, if no apply, and if no appeal is timely filed with the presiding officer's decision, substitute the final agency. B. A party may file the appeal within 25 days of the service of the appeal, but the reply shall be supported with the reference. Applicable laws, regulations will specify the reference to the record. If the party relies on evidence contained with the record, the administrator may extend the period fulfilled with the appeal with a response with the good cause shown, but provided with a written request for the extension served with both the expiration and the application applicable provided with in this section. The administrator's sole discretion is permit or arrangement of the appeal. The administrative own initiative written motion of any of the party administrator may grant the party the opportunity for the oral argument. E. The administrator may remand, vacate, and affirm the reverse, alter, and modify the decision. Presiding officer administrative decision can constitute the final agency action except for the terms of administrative decision. For example, the remaining of a case to the presiding officer showing that the party's administrative remedies have not been exhausted. When a party files an appeal with the Locomotive Engineering Review Board, the decision pursuant to 24403, the administrator may affirm and vacate the board's decision and may reprimand the petition board further than proceeding with the administrator's decision to affirm the board's decision constitutes final agency action. And this shows the schedule of civil penalties. And we're going to cut there at the subpart F.